I want to talk about this claim that there's been a 70% decrease, since Title 42 went away. And it looks like they're counting the encounters at 3,500 compared to the peak of 11,000, the actual record number, which happened right before that. But what they're not counting, it's very interesting, I don't know any of the witnesses that can confirm this, but that we're not counting the CBP-1 app appointments, as I understand it. Is that correct?
That is correct. So the numbers that are being cited by the department are Border Patrol numbers. Those are encounters between ports of entry. So they talk about, I believe, a 70% decrease. What they're not telling you, they're actually capturing the number, but they're not including it in their press release, is the number from OFO, which is the Office of Field Operations. They're at a port of entry, are the number of inadmissibles that are showing up at ports of entry. And what's happening is they're being shifted between the ports of entry to the ports of entry.
It's a shell game, basically. We're taking the numbers out of these and we're not reporting them over here, and we're allowing for appointments to be made through CBP-1 app, and then saying that that's a lawful mechanism of entry. Mr. Edlow, is that in congruence with the law? Is that a lawful entry just because you fill out an app online?
No, it's not.
So it's a violation of the law.
It's a violation, and frankly, if somebody comes to the port of entry, has no documentation to get in, there is a lawful mechanism for them to claim credible fear and to move through that process, but to just allow them to come in, to parole them, not on a case-by-case basis, I might add, but as a group, is not within the confines of the law.
It's against the laws passed by the United States Congress. Okay, so again, kind of digging into this a little further, this group of, and I think the amount of the appointments are about 1,500 or so a day. Add that to the 3,500, add that to the number that don't schedule an appointment and come through, that we don't know that number because they're not reporting that number. Has there really been an appreciable decrease, in your opinions, since Title 42 went away?
I do not believe that there has been a decrease in the numbers. It is a shell game. And the other thing I want to point out too is it's very selective about what day they choose to compare the numbers to. You need to look at a little broader amount of time. The border for my entire career was systematically getting more and more controlled, and we are actually driving those numbers down. You have to look at it longer, not just one day in time.
Mr. Wolf, on May 10th, reporter and immigration analyst Todd Benzman reported ahead of the expiration of Title 42 that Mexican immigration officials were informing him that they were coordinating with DHS personnel on the other side of the border to move illegal aliens from the Mexico side of the Rio Grande to the American side. In other words, they were helping aliens illegally cross into the United States. This would violate, as I understand it, Section 274 of the INA, which prohibits aiding and abetting illegal immigration or helping someone enter the country. In your opinion, would such an intentional coordination on a high-profile stage have been conducted without the approval or foreknowledge of the Secretary of Homeland Security?
No, you would need to have approval up and down the chain of command.
So basically, again, violating the laws of the United States, you think that authority, I mean, the Border Patrol guys would never do that without the authority of the Secretary. Is that what you're saying?
It's hard for me to say whether the chief of the Border Patrol was aware, or whether that made it all the way to the Secretary or not. I'm not there, so I can't testify to that.
I can't imagine they'd willfully break the law without the Secretary giving them approval, but that we'll dig further into that later. The interim final rule that came out, Mr. Edlow, can you discuss a little bit about how this basically upends the entire intent of the laws of Congress from the INA?
Certainly, Mr. Chairman. When the Homeland Security Act was signed and enacted in 2002, 2003, most powers that had been exercised by the former INS were moved over to the new DHS, specifically with asylum to USCIS, where asylum officers were conducting interviews. However, after a credible fear interview, the way it always had worked was that the alien would then go before the immigration judge. That powers were never transferred as part of the Homeland Security Act. This rule does shift that authority from DOJ to DHS having a second bite at the apple to have
Speed people into the country, basically, not have to go
correct.
through the immigration judge process.
But not only that, sir, but the fact that they do not require a new asylum application really does limit the ability for anyone to assess whether there's a valid claim or not.
My time has expired. I yield to the ranking member.